Good morning, everyone. My name is Malia Schultzman, and I'm a staff attorney with the National Housing Law Project in San Francisco. We are a technical assistance provider for Office on Violence Against Women, legal assistance for victims grantees, and transitional housing programs. What that means is that we have the honor and privilege of serving all of you and helping you with all the great work that you do on behalf of survivors of domestic and sexual violence. We're happy to provide training, answer your questions via phone or email, and provide you with materials that are helpful to you in your work. You'll see at the end of the PowerPoint our contact information in case you want to get in touch with us with any questions or comments. With that, I'm now going to turn it over to my colleague, Catherine Bishop, who will be leading today's training. Thank you.
Thank you, Malia. And good morning to some of you and good afternoon to others. I am Catherine Bishop. I'm a senior staff attorney at the National Housing Law Project. And again, it's also my great pleasure to welcome you to the webinar for legal services advocates and transitional housing providers. This webinar will focus on resident rent for federally assisted housing programs. For those of you who are representing or serving survivors of domestic violence and sexual violence. We have a wonderful group of experts here to present the material and answer your questions. Before we begin, I just want to remind all of you that you can submit questions in the question box so that as you go along, certainly if you're having any difficulty understanding what we have said and you want some clarification, please type in a question there and we'll try to answer that question immediately. Other questions we'll try to answer at the end, or if it pertains to what we're doing, then Malia will try to field those questions and answer them as the issue arises. So as I said, today we have a great panel of presenters. First, we have Matt McCrae, and he is the lead attorney in the housing unit at Greater Boston Legal Services. He's with an OVW, Legal Assistance for Victims grantee. And Mac has been with GBLS, Greater Boston Legal Services, since 1982. And prior to that, he was a staff attorney at New Haven Legal Assistance. Barbara Zimble and Linda Garcia are also with Greater Boston Legal Services, and they have given Mac and me invaluable advice on our presentation today on the rent issues and income issues that confront survivors of domestic violence. And they are going to join us to respond to questions. Barbara Zimble has been a legal services attorney for over 30 years, and with Linda Garcia and others at Greater Boston Legal Services, she's focused her work on the housing rights of domestic violence victims, trying to identify and change laws and institutional barriers that keep women from accessing and retaining housing resources, which would help them and their families remain safe. She works with individuals and advocacy groups on legislation, administrative advocacy, and individual cases, and also prepares and participates in training such as this, and also in other trainings in the community in which she works. Linda Garcia is a lead paralegal in the housing unit of Greater Boston Legal Services, and she's been there since 1978. You see, we have an enormous amount of experience on this session today. Some of her work involves access to housing with a focus on domestic abuse, relocation of domestic violence, and victims of violent crime. She's worked on state legislation and administrative advocacy with housing authorities and agencies in Massachusetts that have an oversight of major housing programs. As I said earlier, please submit your questions in the question box. If questions arise after the webinar, you can contact me at cbishop NHLP, or you can contact Malia at the same email address. Today we're going to cover issues related to the definition of income and how tenant share of rent is determined for the 3 major HUD-assisted housing programs. That's public housing, the voucher program, and project-based Section 8. You know, why is this important? I know you all know this is important, but I thought that it might be important to sort of like list out some of the issues that we see, that Barbara and Linda have seen, that Mac has seen when dealing with survivors of domestic violence. Certainly, the first thing is just knowing the rules will help a survivor navigate the system and preserve or obtain affordable housing. Survivors of domestic violence face these common issues. You know, the abuser has moved out. That's going to affect the survivor's rent calculation. The housing authority or the owner wants proof that the abuser has moved out. The housing authority or the owner of the housing includes in rent calculations income from assets that the abuser controls and that the survivor can't access. Due to abuse, the victim failed to recertify, lied to the housing authority or the owner because of the abuse about income and other issues, or where the abuser lives. That, again, is going to impact whether or not she's able to retain her housing and how her rent is set. Other issues arise because the survivor is not listed as head of household, or maybe she's not even on the lease, and therefore there's problems with accessing the family file, continuing to be rent subsidized, etc. And I'm certain that all of you on the call could also add other situations that you have run into that affect your client or the person that you're serving income and hence their rent in the federally assisted housing programs. The materials you received, I hope, the PowerPoint that we're going over today that you have in front of you, and hopefully you've been able to print it out and you can take notes on it. The materials and the recording will, after this session, be posted on our website. And for those of you who are California advocates, the certificates will be mailed to you or emailed to you. Now, I know that, at least for some of you, understanding the federal housing programs is an issue that you feel like you need to know more about. I'm just going to do a very quick review just to orient everybody here in terms of what we're talking about. And we will have another session that will go over an overview of the federal housing programs, and we'll be doing that sometime in November or December of this year. You will see for each of the 3 major housing programs, after each of it, if you want to find where the housing authority is located in your community, just Google Find HUD Rentals, and you will find the PHA in your jurisdiction. The same thing for if you're trying to get a voucher for your client. You don't know what housing authority the person that you're dealing with is subject to, but you know the jurisdiction she lives in. You can again Google Find HUD Rentals, and you will come up with the housing authority for the jurisdiction that you're concerned about. For the project-based Section 8 program, the URL that's up there will give you a list of Section 8 developments in your community. So that may help you determine what kind of housing you're dealing with. Certainly if the housing is listed on that list, then it is more than likely a Section 8 development. The fact that it's not listed may not mean that it's not Section 8 because sometimes those lists are wrong. All right, public housing. Public housing is owned and managed by the Public Housing Agency, often known as the Public Housing Authority. The Housing Authority determines the eligibility of the individual for the housing, the rent, they determine transfer policies, and they also decide whether or not to evict the victim or the abuser or just any tenant in public housing. With project-based Section 8, that's owned and managed by a private entity. It may be a for-profit entity, a nonprofit entity, or in some cases a public entity such as a public housing authority, but that's rare. And it's the owner or the agent of that development that determines eligibility for admission, determines the family rent, and determines whether or not to evict the family, and may determine also whether or not to stop the subsidy payments for that family, but not evict them. For the voucher program, and in your jurisdiction, you will find that there are a lot of sub types of voucher. A main one that's coming into the fore now is something called project-based vouchers, different than project-based Section 8. In the voucher program, it is the housing authority, both for the voucher, which is sometimes called the housing choice voucher, or the Section 8 voucher. It is the housing authority that determines eligibility. It's the housing authority that determines rent. It's the housing authority that determines if or when a family can move, and it will also decide whether or not to terminate the voucher. It's a private landlord that determines whether to evict the family, and the voucher program is unique amongst all of the programs in that when a tenant moves, she is able to take her subsidy with her. I realize that's a very brief review, but as I said, we will have another session later this year on the basics of these programs. Now, a few things to start with respect to the voucher program.
Kathy, before you get into that, I'm just hoping we can quickly see who's joined us today in terms of who our audience is.
Sure.
If that's okay. Great, thank you. So we're just going to run a quick poll right now because we want to get a sense of who's in the audience today and also let you all see who's joining us. And we're going to ask you which best describes you. Are you a domestic or sexual violence program staff member? Are you part of transitional housing staff? Are you a legal services advocate or attorney, or do you fall into the category of other? So we'll just give you a few more seconds to respond. All right, and it looks like we have about almost everyone has now responded, so I'm going to close the poll and share the results with everyone. So we have a great mix today amongst domestic or sexual violence program staff, transitional housing staff, and legal services advocates and attorneys. So it'll be great to hear, based on your comments and questions, the different types of experiences you've had on these rent issues in your jurisdictions. And before we get on into the substance of the rest of today's training, I want to run one more poll just to see how many of you are joining together on this webinar. So the question is, besides you, how many others from your office are attending this webinar with you? So go ahead, and we'll give you a few seconds to respond to that, just because I know that a few of you are sharing your login today so that we could maximize the number of programs who could join us on this webinar. All right, so it looks like most of you have voted. And just to share the results, several of you have one other person joining with you. And then we have some of you have 2 or 3 others from your program sharing this webinar today. And so we really appreciate those who are sharing your logins and participation in the webinar, because that helps to maximize the number of programs that we can serve. So with that, I'm going to go ahead and turn it over to Kathy so she can get back to the substance.
Thank you, Malia. As I was saying before, there's a few things just to start, again, just to orient you in terms of the terms that are used by the housing provider and by the tenant is that there's a distinction between the tenant portion of the rent and the full contract rent for the unit. The full contract of rent is the total amount received by the owner for the unit. The tenant portion, well, it's actually, the contract rent is easy to figure out for both the voucher program and the multifamily. I say easy in terms of if you're able to get the documentation, because it's on the rent forms that the applicant or the tenant receives, and you as an advocate should be able to get that from the owner or the housing authority. For public housing, there's nothing quite like this because they don't have a contract rent. They certainly determine the tenant portion of the rent. And then also to remember that rent includes what the tenant pays for utilities, so that gross rent is the combination of the contract rent and what the tenant is expected to pay for utilities, or the utility allowance. Now, of course, the utility allowance may not be the same as what the tenant actually pays for the utilities. You will hear often that people will say, clients may say, you know, I pay Brooke Act rent or Brooke Amendment rent, or the housing authority or the owners may say that. And that is the amendment to the United States Housing Act that sets forth the total amount of rent, total tenant payment that the resident is required to pay, and it is the highest of 30% of adjusted income. The other two standards, 10% and minimum rent, are used less by residents. We'll be talking about minimum rent below. This is the only discussion here that we'll have of the 10% of annual income. That's 10% of gross income without any adjustments. The vast majority of tenants pay 30% of adjusted income. Okay, so now what is the minimum rent? The minimum rent for the public housing program is anything between $0 or $50 a month. For you to determine what the minimum rent is in your jurisdiction, you should check what is called the Admission and Continued Occupancy Plan for your housing authority. That should tell you what the minimum rent is. Of course, you could just call and speak to a staff person, and they may be able to tell you what the minimum rent is also. For the voucher program, again, the housing authority determines what that rent can be. It's set forth in the Section 8 administrative plan. Again, you should be able to get a copy of that administrative plan. Staff may be able to tell you what that minimum rent is, but it also should be listed in that administrative plan. For the project-based Section 8, where you've got the private owner, HUD has set the minimum rent, and HUD set it at $25 per month. Now, any tenant who is receiving minimum rent can get a suspension of that minimum rent. And they can get a suspension for economic hardship, which is temporary, less than 90 days, or they can get a complete waiver of that minimum rent if the economic hardship is for more than 90 days. Now we have a poll question here, Malia.
All right. So as Kathy said, housing authorities and owners have an ability to suspend the minimum rent for tenants who aren't able to pay it due to economic hardship. So we just wanted you to see if you could give your best guess about what percentage of housing authorities actually grant that minimum rent exception to more than 10% of families. So we're asking you basically, how frequently do you think that housing authorities grant that exception to the minimum rent? In other words, grant an exception to the requirement that somebody pay that minimum $25 or $50 a month. So keep on guessing. And it looks like most of you have voted. So I'm going to go ahead and share the results. So we have a very cynical audience here today. Most of you think that, you know, the majority of housing authorities aren't granting this minimum rent exception. And so I'll let Kathy tell you actually how frequently housing authorities are granting this important exception to the minimum rent.
There was a HUD study that showed that 5% of the housing authorities that responded said that they gave an exception to more than 10% of the families on minimum rent. Now, certainly 5% is a very low amount, and certainly the fact that people our income is low enough that they're paying a minimum rent, certainly the exception and the hardship should be dramatically higher than that. And it really is one of those things that's the best kept secret, that housing authorities and staff do not let residents know that they can get a waiver or a suspension of that minimum rent. And it is an important right that residents do have.
Catherine, this is Mac. One additional thing for people to watch out for is there's a live discussion in Congress right now about whether or not minimum rents may go up, and it's something for people to watch during the coming months.
That's right, and they're thinking of increasing it dramatically to, close to $70 a month.
And Kathy, just to clarify, this is Malia. Are there situations in which domestic violence might fall into that economic hardship category that would make someone eligible for a rent exception?
Yes, of course. First of all, just the idea that all of a sudden if the abuser is the sole source of income and the abuser moves out, then the family has had a dramatic change in income. The victim doesn't have any income. She can request a minimum rent, and then she can request an immediate waiver of that minimum rent. So now, does everybody pay Brooke Act or Brooke Amendment rents? In public housing, actually, there are a small group of people who pay more than 30% of income for rent. They pay a flat rent, and that flat rent is a rent that is based upon the market rent for the unit, and that is something that a housing authority should have a chart of the flat rents that it will charge for each one of its units. This is something that is available, generally speaking, to individuals who are slightly higher income, and it's an advantage to them because they don't have to recertify every year. They only have to recertify once every 3 years. But if they're paying that flat rent, they can immediately adjust back to a Brooke Amendment rent if circumstances change. Voucher tenants also may pay more. And the reason that a voucher tenant may pay more than 30% of their income for rent is because the gross rent that the landlord is asking exceeds the subsidy that the housing authority will pay. The maximum subsidy that the housing will pay for the unit is called the payment standard. If the rent that the owner is charging is reasonable, and let's hypothetically say it's $10 above the payment standard, that extra $10 the tenant must pay in addition to 30% of their income for rent. In the project-based Section 8 program, tenants pay 30% of income for rent. There are adjustments to rent. Once you determine what a family's income is, then there are some standard deductions. $400 a year if you're an elderly or disabled family. That means your head of household is either elderly or disabled. You have some control over that in terms of who you designate to be your head of household. $480 for each child under the age of 18, or an adult who is a full-time student also gets the deduction of $480. There's a deduction for child care expenses for the care of a child under the age of 13, so long as that is to allow the head of household to work or train, or go to training, go to school. There's a medical expense deduction of 3% of annual income, and a disability assistance expense also in excess of 3% of income, and that medical expense and disability assistance expense can be combined, but those are available only in the case of the medical expense to an elderly or disabled family, and the disabled assistance expense is only available to allow an individual with a disability to work. Medical expenses include the items included on this slide, which I think that you can read through as I am going to turn this over now to Mac. As I asked Mac a question here, we're at our first problem, and we have a situation where you have a survivor of domestic violence. She obtained an order for protection from her abuser, and her abuser moved out. The abuser was the sole supporter of the family and was ordered to make payments to a bank account for the survivor for support. The survivor gave the order to the housing authority. The abuser has not been making payments to the survivor. What should the survivor do? And maybe it would be helpful if you have some suggestions in terms of what the survivor should do, maybe you should type them into your question box.
Meanwhile, I may start giving some thoughts on this question. So the very first problem you're going to run into is some housing authorities or housing providers are going to still treat it as if that abuser is still in the apartment, even though he has been ordered to leave. And they may say some stupid things like, oh, you need to go get a piece of paper from him saying that he's moved out. Or you may need to get a piece of paper from him proving that he's established another address somewhere. And obviously, that's going to create some risk factors for your client. In a domestic violence situation, far more than in sort of the normal situation where this can come up without domestic violence all the time and there's just a change in household composition. So that's the first problem that the survivor may run into. Obviously, she can provide a copy and has provided the housing authority a copy of the order saying that they cannot live there anymore. If request is made for where he is living and it will pose a risk, that's something that absolutely the VAWA protections would apply to, and the statements about risk and confidentiality would apply to. And perhaps some best efforts, if she has some idea of where he's gone to, fine. But if by asking any requests or information from him will put her at risk, she should not be required to do that. The second issue that's going to come up is they're going to look at that bank order, at that order about payments to the bank account, and they're going to say, well, child support is income to the household. We're supposed to count that income to the household, and since it's been ordered, that's what we're going to do. And one of the things you may run into, particularly if you're talking about multifamily housing, is that owners have been told by HUD that they need to exhaust efforts to collect child support first before just assuming that someone's not getting child support. So they may run the client through the ringer of saying, oh, well, what have you done to chase him down about getting that support paid when you're not getting it? And obviously, similar issues about risk may arise as to why it would not be a good idea to pursue at this particular point, and that can be documented, and the Housing Authority should accept that under VAWA. There may also be ways to just document that here's in fact what's been coming into the bank account, similar to oftentimes coming back and rebutting the assumption that the court order says what it is, because in fact this is what's getting received. But just be aware that that may be the normal mindset that some providers have, not necessarily from bad intentions. Sometimes it's because they've gone through bad HUD audits before and are a little bit gun shy because of that. And so instead you would be saying, this is a VAWA risk. Here's the documentation. It really is not reasonable for me to be pursuing this in the meantime. Couple other thoughts. It's always important for the client to be doing this as soon as possible when there's a changed circumstance. And we may be talking about this later in the materials, but different owners have different provisions, and different programs have different provisions about how quickly rent changes are supposed to take place. For the multifamily programs, rent changes are supposed to take place effective as of the first of the month after the change has occurred or after the change has been reported. For other programs, it may depend on the Housing Authority's written policy, its ACOP or its Section 8 administrative plan. But it's always in a client's interest to report sooner rather than later, because the PHA or the multifamily owner may say, oh, well, you sat on this information for 3 months, and so I'm sorry, but we had to deem that income as coming into you. You might try to pursue VAWA relief on that, and I think that's somewhat uncharted territory about whether or not you could convince either the provider or a PHA or HUD to grant retroactive relief in those circumstances. But that's one thing to do. And in addition, they may then be coming back to you and saying, oh, well, you've got no income coming in now. He was the person that was providing the support. He's not providing any income. He's not providing any of the court-ordered support. And then they may be charging the minimum rent. And then you may need to be coming back with, is there some exception to the minimum rent? You may be faced with first getting the suspension for the initial 90-day period, because it's not clear whether or not there may be, the court order may kick back in, or whether or not the client may be eligible for some other form of income within 90 days. But certainly you could be pushing the issues about both suspension and eventually waiver of the minimum rent for the hardship circumstances that exist under the law.
The only thing I'd add to that, Mac, is just that there is some authority for, when you're trying to say, well, the Housing Authority or the owner says, we need independent verification that the information that you're telling us is the truth, is that there's some support, even out of the context of VAWA, that the Housing Authority or an owner can, if they document in their files why no third-party verification is possible, then they have set themselves up so that in theory they could pass that rigorous audit that HUD may provide to them.
Right, and they could accept the victim's or the survivor's own statement about those things if there did not appear to be anything else that they could obtain.
That's right. That's right. And so, Mac, the next slides are yours.
Okay, sure, okay. So the next slide is about what's counted in your annual income. If you could click on to, I don't think I control these slides.
Yes,
okay.
yes, my problem here. Yes.
Right, so there's a question about what's counted in everyone's annual income, and the owners and the PHAs go by what your anticipated or projected income is for the next 12 months. And they can rely on what your past income has been to project your future income, but if you have something that's more recent to show that that's inaccurate, the tenant can go back and push that instead. So let's assume that they said, well, you were working full-time, and so we project you're going to have $20,000 worth of income, and because of family breakup, you're now only able to work part-time, that your hours have been reduced, or or someone's gotten sick. All of that information should be things that you could bring in, or that you were working seasonally and maybe you had an increased shift during the holidays, but that's no longer the case. They count the earned income of all adults who are 18 years of age or older. There is an exception for those who are full-time students over the age of 18, other than the head or spouse. In those cases, they only count $480 of that earned income, but they will require some kind of verification that the person has full-time student status in terms of what their study load is. They do count unearned income for minors, so Social Security dependent benefits or SSI benefits or TANF or other forms of unearned income for minors would be counted. And welfare benefits are generally counted for the household. In addition, on the next slide, there's information about assets and lump sums that need to be obtained. And this can oftentimes be quite cumbersome and tricky in cases where there's been domestic violence or family breakup. They have to get information about bank accounts and other forms of assets that might exist, which could include things like inheritances, or could include things like real property that maybe you ended up having an interest in because some relative passed away and you've got some interest in it. And they have to then determine if there's income that's earned on that asset. If it's what's called a net family asset and it exceeds $5,000, then they don't look at whether or not you're actually earning income on that. They will deem an interest value earned on that asset by using their current HUD passbook rate. But just be aware that the net family assets don't count things like cars, clothing, or furniture. You might have some exceptions, though, if somebody thought, well, that's not really normal clothing, like those diamond rings that you have that are more than your ones that you're actually wearing day to day. You could run into that as a problem, but that's not usually the most clients' circumstances. And in addition, you have issues about lump sum income. I'm sorry, if you could go back, Catherine, to slide 17. If there are lump sum awards of Social Security, SSI, or OASDI benefits, or Veterans Disability Awards, those don't count as income, but other lump sums are included. So sometimes you may have a client who's been waiting for a while for an SSI award. They start getting SSI, and a part of that is retro benefits. The retro portion does not count, but what's going forward would need to be counted and would need to be you'd need to give notice to the owner of that. So let's move on to problem number 2.
Hey, Mac, before we do that, can I insert a brief question?
Yes.
The question is, does this include Social Security disability income?
The lump sum, yes. Yes, the lump sum awards of Social Security disability income, same rule. The lump sum portion does not count, but ongoing Social Security disability income does count. Okay, so let me, we're going to switch things around here, and I'm going to pose problem number 2 to Catherine. So you have a survivor of domestic violence who's seeking admission to a project-based Section 8 development. She tells the owner that she has a joint savings account with the abuser, but she's afraid to access the funds for fear of retaliation. The owner says that it must include the value of the account in the income for rent-setting purposes. Can the owner do that, and what more would you like to know?
So that if you want to, you can type in some answers to this question in terms of, do you think the owner can do this? And you can also type in, if you'd like, what more you'd like to know. And in addition to that, while you're doing that, I just want to point out at the bottom here, in terms of the answers and resources, that we have throughout some of these answer and resources, we have cited 3 different handbooks. One is 4350.3. That is the handbook that's applicable to project-based Section 8. We've also cited the guidebook, the 7420.10. That is the guidebook for the voucher program. And we've also cited something what we call FOG, or Public Housing Occupancy Guide, and that is for the public housing program. All of these guidebooks and handbooks are available on the HUD website. In terms of answering the question, can the owner do this? It's sort of like there's a 2-step answer to that question. First of all, the owner can't do it in terms of the owner should not be including the whole value of anyone's assets in income. It's just the interest on the income that should be included. For this particular client, because she cannot access the asset, she should, the income or the actual income or the imputed income on that account also should not be included in her income for rent setting purposes. The handbooks support the idea that only an asset that you have under your control or that you have access to should be included in your income. And the 4350.3 handbook that goes to project-based Section 8 specifically gives the example of somebody who is subject to domestic violence. Advocates often are able to use guidebooks from different programs that have beneficial language in supporting their arguments, because really these handbooks, even though one may mention domestic violence and the other doesn't, as in the example here, they're really interpreting the same law. And so that those handbooks should be consistent. What's the explanation for them not being consistent? Part of it is just when the handbook was written and that the particular handbook has not been updated. It appears that generally speaking, HUD seems to be more facile at updating the handbook 4350.3 than they are in updating the voucher guidebook or the public housing guidebook. Although we were told 2 years ago that HUD was involved in updating the public housing occupancy guide, but haven't heard anything since that. I don't know whether you want to add anything more to...
The only thing I would add is that, generally speaking, HUD Handbook 4350.3 has a lot more detail on certain issues, for example, the treatment of assets. And so oftentimes you may, if you're in a different program, have to argue by analogy with your public housing authority. But much of the time, if you get more senior staff there, they'll agree with it because they'll say, well, this is HUD's word on this, and this is what HUD would say if it was directly administering this program. And if not, it is the kind of thing where the HUD regional office may be helpful. So we should probably switch to number 19, which is you can have situations where you're getting help from others that aren't in the household.
Oh,
and the question of what...
really fast?
So
Absolutely.
we just got a couple of delayed responses to that problem.
Okay.
So the advocates want to know if you had a court order indicating that the couple is separated, or a divorce order, or a protective order proving the client could not access the account, would that help your case?
Yes, that absolutely would be helpful.
Right, because all of, well, actually the public housing one is not quite as clear, but the 4350.3 handbook and the voucher guidebook both talk about the fact that the asset must be controlled or accessible to the family. And so that if you've got something that says it's not accessible to the victim, that should be very helpful. The only language in the public housing occupancy guidebook is just the language that we have on the slide there, encouraging the exercise of discretion when they obtain negative reports relating to DV.
Okay. So is there anything else on that, Malia?
No, that's it.
Okay. On slide 19, sometimes you're getting help from others that aren't in your household, and the question is, can that be counted as income? And the answer to that is, if it's just a sporadic assistance, it's not regular, or it's a one-time gift, you don't count that as income to the household. But you might have situations where, let's say, someone who's not living with you is regularly paying your light bill, or is giving you, $50 each month to pay toward your grocery bill, or helping you pay your cell phone bill, or things like that. That can be counted as income, even though it's not directly from someone who's living in the household. And the trickier part that happens with this one is where clients come forward and say, I've got no income. Some housing authorities, and in fact HUD itself at one point, have these very detailed and draconian questionnaires that ask all kinds of information, like how are you supplying these things that are in your medicine cabinet each month, or how is the cable bill getting paid, or things like that. And if the answer is there is someone helping out on that and it's regular, they can count that. Now, food stamps are not counted as income. There are a number of specific exclusions, of which food stamps is one. So we have a third problem here, and I think this one Catherine's going to read to me.
That's right. And so the next question is, Brenda recently separated from her abuser. She's scrambling to make ends meet. She's getting some support from families and friends to stay in the unit, pay the rent. The housing authority is requesting proof that the abuser has moved out. What does Brenda do? What are the consequences of her actions? Some of these issues we've addressed previously, but some of them I think are new.
Okay. So the problem that we addressed previously was about the question about the proof that he moved out. In some cases, she's going to have that proof, but in other cases she's not. Notice this is not one where we say that there is an abuse prevention order. So here, Brenda's just going to the housing, to the PHA saying he's not here anymore. And of course, the PHA has many situations in which people come to them and say, oh, that income contributing person is no longer here. And then they find out months later that they were there. And so they've become distrustful of that and are oftentimes looking for proof that the person is in a different address. And where there's risk involved, that's something where you can say, nope, but here's my best information that I have about where he is, or here are some places that you can try to get that information. But again, she could provide her own third party, her own statement on it if there can't be kinds of verifications, or if verifications would put her at risk. So that's the first issue, which is about proving that he's somewhere else. But, of course, the question you've got here about the support from her family and friends is going to be, what kind of support is she getting? How often is she getting it? is it something that's going to fall within that non-recurring, sporadic, or gift income, or on the other hand, is it going to be something that would be considered to be regularly enough? One of the cases that we've mentioned in materials at the bottom of this slide is actually a really nice case pre-VAWA out of Missouri called Housing Authority of County of St. Louis versus Boone. Precisely this situation. They've separated. She goes to the Housing Authority. The Housing Authority says, unless you can get a statement from him that he's moved out and tells us what his new address is, we're going to continue to count him as part of the household. We're going to continue to deem his income as being available to you. And they went ahead and proceeded forward with an eviction case against her for non-payment of rent, counting his income. And it was the court said, nope, she did what she was supposed to do. She gave you the best evidence that she could. Her rent should get adjusted to being it. At the same time, it was very interesting because the court there basically did a bifurcation similar to what's in VAWA and said, but he's still on the hook for this other rent as to his share because he hasn't stepped forward to do what he should do. But you can't evict her. She's done what she should do, and her share should get adjusted.
And Mac, we have sort of a follow-up question. And you may have answered this, but I just want to reiterate it. The advocate says that some housing authorities request from survivors evidence of a divorce case being filed to prove that the parties are separated. Is this a valid request, and can the housing authority ask for that?
No, I do not think that the housing authority can ask for that. The questions about whether or not to get divorced are very different from the questions about whether or not people have separated or whether or not there is abuse or domestic violence or just family breakup going on. Certainly the housing authority can be looking for some kind of verification or statement that the person is no longer in the household and does not appear to have any intent to return to the household. But requiring proof of actual divorce, no. That's a different. That's a completely different matter. It's similar to housing authorities that sometimes say to people, well, you know, I won't adjust your rent unless I know you've applied for welfare benefits. And the housing authority can't do that. Housing authority can require verification as to what all the different forms of income are that you might have gotten or weren't receiving, but they can't require that you specifically seek some form of income.
All right, and I just want to quickly address another question that came in. Somebody asked, would a copy of a kick-out order or protective order be sufficient to prove that the abuser is no longer in the household? And I think we would agree that that should be sufficient proof.
Yes. The issue you may run into as well is sometimes there are temporary abuse prevention orders, and the housing authority may have a question if that order expires after a certain number of days, and so then the survivor may need to go through some extra steps explaining why the order wasn't extended, but why the person is no longer there. That might come up.
So now we're on to the next slide. You know, what happens if income fluctuates? And certainly families' income does fluctuate. Certainly in the case of domestic violence, it often fluctuates because often the abuser is the source of income, or at least either source of all the income or certainly part of the income. And the obligation to report is going to depend upon the program and the PHA policy, and we'll discuss that a little bit later. As Mac said previously, you know, an owner or a PHA can count overtime, can count sporadic jobs in figuring out and averaging a projection for future income. Certainly a tenant can seek a change to this if the hours or rate of pay or if the job was just temporary. And sometimes a client is best off if they kind of like agree that what they want to do is that they want to come in and have their income recertified on a shorter schedule. And I think that because the Housing Authority can do that, they can say, okay, well, we want you to recertify every 3 months because we don't know what your income is. If they take the position of, no, we are going to spread this income throughout the year, if in fact after a 3-month period, if the family's income suddenly drops or is different, then the Housing Authority takes the consequences of spreading that income out over a full year as opposed to doing it by the months that it is coming in. Annual recertification, it's required for all programs. A public housing authority, if in fact the family lives in public housing, can start an eviction action if the tenant fails to come in for recertification.
And can you just back up briefly and explain just basically what recertification is?
Sure. A tenant, when they initially move into public housing or receive a voucher or into project-based Section 8, their income is reviewed. There is a certification, at least in terms of the jargon used in these programs, there's a certification of the tenant's income, and rent is set on that income. For most tenants, it's set for a year period. Tenants are required then to, both by statute and by practice, to annually recertify that income so that anticipating that income will change, therefore their share of rent will change. And we will be talking about interim recertifications, interim between annual recertifications later on. So right now we're talking about annual recertification so that every tenant must recertify their income on an annual basis. And a housing authority, in order to enforce this provision, can start eviction proceeding against a public housing tenant or a termination proceeding against a voucher tenant if the tenant doesn't complete the recertification on time. Most housing authorities for the voucher program and the public housing program have a procedure whereby they notify the tenant generally a couple of months prior to the process saying you must come in for your annual recertification, and we'll send several notices to the family. For project-based Section 8, the penalty if the tenant does not recertify on a timely basis is that the rent is increased to market. The tenant doesn't get immediately evicted, although because the tenant often can't afford that market rent, it ultimately ends up in an eviction action or has the potential of ending up in that. And the tenant may be stuck with these charges until they are able to complete the recertification process. Fortunately, in the project-based Section 8 program, the owner must stick to some very specific procedures that are in the HUD handbook regarding timing of notice for annual recertifications, what must be in the notice in the annual for the annual recertifications, and as you'll see in the next problem, there are a lot of cases that have been brought where the owner didn't follow that particularly tight, rigorous schedule, and it had adverse consequences for the owner who was trying to evict. The effective date for rent increases for an annual recertification, normally a tenant would get a 30-day advance written notice of a rent increase. I say normally because in the public housing and voucher program, that has got to be, it's got to be in the ACOP or the administrative plan what kind of notice is given of a rent increase. There are no federal regulations on an increase in the rent due to changes in family income. And if the delay in completion is not due to the tenant, but is due to the housing authority or the owner or a third party, the tenant should still get the full notice of the rent increase. And this arises because sometimes with a third party, the housing authority is sending out notices to an employer, the employer is not responding back, or the housing authority or the owner begins the process of the annual recertification late, or doesn't follow up if in fact the tenant doesn't follow up. And so the fault is on the housing authority or the owner for not pushing forward with the annual recertification process. So now we have another problem that I'm going to ask Mac to respond to. Yvonne lives in a multifamily housing with project-based Section 8. Due to the abuse, she and her children were away for a while. When she comes back home, she finds that the owner has increased her rent from $200 a month, that's her share of income, to $1,500 a month, and saying that she missed getting her annual review papers in on time. That's why the owner has increased the rent to $1,500 a month. What do you advise her to do?
Okay, and I know that in the bottom of the slide there are a number of resources that are mentioned here. For the HUD multifamily program, there is a model lease, and there's a provision there about the failure to report allows the owner to impose a penalty, but the owner must notify the tenant about the right to meet to discuss this. And oftentimes owners, in fact, don't include that language in the notice. It's important for the tenant, once they are on the scene and have someone who's giving them some advice, to respond to the owner right away to say, here's the information about my income, here's why I didn't respond earlier, and I'm requesting a meeting. In addition, there is a provision in the multifamily handbook which talks about extenuating circumstances, and although there's nothing specific yet in that handbook about domestic violence, they certainly include a number of other examples which it's very parallel to. For example, where someone was hospitalized or had some kind of family emergency that came up, and that was the reason that they were not present at the time that recertification needed to be completed. And it provides that if extenuating circumstances are raised, the owner must review that and must make a specific determination about that, and it actually gets reviewed by somebody other than made the initial review. As Catherine mentioned earlier, this one's one where you want to sort of closely review all the different notices that were sent, because I would say in at least 60% of the cases I've seen, there's some mistake somewhere in this paperwork, and so usually you can get things rolled back so that you can get it just to an income-based rent, and there's a number of cases there, particularly the ones from New York State, where this has really gotten heavily litigated. And in addition, obviously, there is VAWA to raise as being a circumstance that was a contributing factor on this. And although VAWA, the four corners of it, may not address this, there's a requirement that termination decisions and eviction decisions be consistent with VAWA, and that would be the hook that I would argue on. But I think that mostly you could use the handbook revisions to get you out of these types of problems.
And the other thing, too, just to emphasize, is that this extenuating circumstances, you know, if the housing owner says, well, I've already submitted the voucher to HUD to get my payment, the extenuating circumstances provision of the handbook is grounds for the owner to go back and correct what was submitted earlier and say, okay, I didn't, I didn't ask for a subsidy for this unit. Now I'm asking for the subsidy, and this is the reason I'm asking for the subsidy, so that they have the ability to correct the paperwork essentially retroactively.
And they will not then face a financial penalty for it, which is what they would be fearing otherwise.
Could you ask a poll question now, Malia?
Sure. All right, so the question is, in what programs, what subsidized housing programs, can tenants be obligated to report a rent increase? I think that should be an income increase in between annual reviews.
That's right. Yeah.
Yeah, so in what programs can a tenant be obligated to report to the housing authority or an owner an increase in their income in between those annual income reviews that we talked about? So I see people are voting. And, this comes into play because you'll want to know, maybe you have a client tell you that the income has increased and wants to know what their obligation is to report that income increase. All right, so it looks like most people have voted, so I'll go ahead and close the poll and share the results. So the vast majority of you think that, in all of these housing programs, tenants have an obligation to report an increase in income, even if it's not at the time of their annual income recertification. So we'll find out more about those obligations now.
I gather we may need to pick up the pace. Am I correct, Malia?
Yeah. So you all have about 15 minutes left.
Okay. Thank you.
Yes. So reporting. Interim reporting of increases in income, it depends upon what that ACOP says, it depends upon what that administrative plan, what the reporting requirements are, and for project-based Section 8, the family only needs to report an increase in income if it's an increase in income of more than $200 per month. Certainly in terms of reporting decreases in income, it's always in the tenant's interest to report this right away. For multifamily housing, there's a good provision in the handbook. The owner can delay processing that request until verifications are obtained, but must retroactive to the first of the month implement the new rent. And during the period of time that the owner is delaying the process, they cannot evict for non-payment of rent. So that's a substantial protection for tenants who are in project-based Section 8. And this is something, there have been a number of things that we've said that you might want to advocate for public housing in the voucher program. Certainly you could use the PHA plan process to advocate for a similar policy in the public housing or the voucher program. We have another quick poll question here.
That's right. So let me go ahead and launch this. So in the Section 8 voucher program, where the client goes out on the private market and rents a home with a voucher, does that Section 8 voucher landlord have to postpone eviction if the tenant is waiting for the housing authority to adjust her rent? So let's say the tenant's had a decrease in income and is waiting for the housing authority to lower her rent as a result of that decrease in income. Can the voucher landlord go ahead and proceed with the eviction even though your client is waiting for the rent adjustment? So people are voting, and I'll give you a few more seconds to digest that question. Okay, it looks like most of you have made up your minds. So I'll go ahead and share the results.
And this is a case of knowing the difference between the two programs, because the thing is that if it's a voucher tenant, if it's a project-based Section 8 tenant, then the answer would be yes. If it is a voucher tenant, the housing authority, even though they are adjusting, they have been requested to adjust the income for the family and therefore the rent, the landlord can proceed with the eviction. Because in fact, the landlord is in a position where they want the rent. They don't, they don't want to wait on the housing authority to readjust it. So it is a thing that you have to be aware of, that until that adjustment happens, the tenant has got to struggle to pay as much of that rent as possible or get some sort of agreement with the landlord. HUD now has a system that housing authorities and owners can use. It's called the Enterprise Income Verification. Survivors of domestic violence often get caught in this, as do other residents. They get caught because they didn't report their income, the abuser didn't report the income, maybe the survivor even, lied about their income. These reports would show what income came into the family using Social Security numbers. Certainly there are arguments that we have presented in answer to other questions about what to do if this happens in terms of using VAWA, in terms of arguments that can be made that, it was the abuse that made me not report this income. Often, in the situation that I've just described, the abuser is going to be subject to some payments, retroactive payments, if they don't do the bifurcation that Mac talked about in the case from St. Louis. But you should remember that there is a HUD notice out there that if a tenant has to pay back unpaid rent, that the future payments should not be more than 40% of the tenant's current income. And so this is a very helpful PIH notice, and it's a PIH notice, so therefore it means that it's applicable to public housing and the voucher program. It's not immediately. Yep.
And there are parallel notices for the housing program as well.
That's right. I'm sorry. I have both notices listed down here, the PIH notice and the housing notice. No, I don't have both of them. Never mind. Well, if you need both of them, I will send them out to you. In terms of, we mentioned previously, in terms of public housing authorities having to pay a flat rent, or having the option to pay a flat rent, and that flat rent is basically comparable to the market, and that a tenant who is paying that flat rent can ask to switch back to a Brooke Act or Brooke Amendment rent when there is an economic hardship. I'm now going to turn this back over to Mac.
Okay, and I may try to go through these relatively quickly so that we've got a little bit of time. So our next slide has to do with the earned income disregard. And I think that's slide number 29, which if we could pull it up, that would be great. Thanks. So this is mostly something for the public housing program. There's a limited program for the Section 8 voucher program for persons with disabilities. There is no earned income disregard at all for the Section 8 multifamily program. And people can qualify for this if they've been employed while on or within 6 months of receiving public assistance, or after 12 months of being unemployed. And unemployment is a term of art. HUD defines it to include some very limited employment, or after participation in certain training programs. And the way the disregard works, as is mentioned in the next slide, is you disregard 100% of the increased income as a result of employment for one 12-month period, and then 50% of the increased income for a second 12-month period. and it's kind of like a stopwatch. The clock stops each time when there's a break in employment. So let's say that someone had to leave work because they couldn't work because of an outbreak of domestic violence. And then they had no income coming in for a while, or maybe were on TANF, or maybe they were on unemployment. Then the housing authority would reset the rent to whatever that income-based rent would be. But then once they returned to employment, then they pick back up. So they would be maybe in the middle of their first 12-month period and would then use the rest of it for employment and then kick into their second 12-month period. There is a rule that it has to be used within 48 months of qualification, the start of the employment, and if for some reason or other you aren't able to use it within the 48 months, anything you didn't use is essentially forfeited. And household member is only eligible for this once. It is a big deal in public housing, and so it's something always to watch out for. We have problem 5, which is a different problem, and so let me read this to Catherine. Sally's living in an elderly development, which is a Section 202 development, and she's got project-based Section 8 assistance. She obtained a restraining order and her abuser moved out. The owner has notified Sally that her rent will increase to contract rent because she is not 62 years old. What can you argue, and what other facts would you like to know?
And the reason we put this question in here is because this is something that is a problem. It's a problem in the handbooks, and so that you may run into it, and we're just trying to highlight that it may arise because at least right now the rules don't seem to address the problem. Certainly other facts that would be good to know is Sally disabled? She may be able to qualify for the housing. It may be senior disabled housing. Be good to know how much demand there is for the housing, because some senior housing also accept people who are defined as near elderly, 55 or older. And as I said, the current subsidized housing handbook says that if an eligible person dies, so that in the situation here where, even though it's not stated here, Sally is under 62, the person that she was living with, her abuser, was over 62, therefore they were eligible to live in this housing as seniors. He moved out, and if he had died, the handbook is quite clear that Sally would succeed to his, would be able to allow to be the remaining member of a tenant family and continue to reside in the housing. And so, your response to this is going to be, certainly that there is an exception in this handbook. You probably are going to have to make this claim to HUD because the owner is going to look at the handbook and say, I can't do this. The ideal situation is if you'll be able to get the owner and Sally to submit a request directly, both together directly to HUD. If the owner won't do it, then Sally is going to have to submit a request to HUD to address this problem. And because the handbook has addressed the VAWA issues in other parts, it seems likely that HUD would address this favorably, but this issue has not been resolved. Did you want to talk a little bit about prorated rents?
Sure. So this would be a training all in and of itself, but people should just be aware that there can be circumstances where you have some members of a household who aren't U.S. citizens and don't have what HUD would refer to as eligible immigration status. Most commonly eligible immigration status is persons who have legal permanent resident status or asylee or refugee status. There are a few other minor categories that would also fit, but unless you fit within one of those, that particular family member is not eligible for rental assistance, and the family only gets partial assistance, what's referred to as proration, which is proportionate assistance. It's important that if status is adjusted, so that if someone was waiting for a green card or legal permanent resident status and obtains it, they need to notify the owner or the PHA about that right away so that they can be adjusted. This obviously can come up in a family breakup or domestic violence situation because it may be that the person who left was the person who had eligible status, or it may change how the proration calculation works, and it's something that has to be examined in each one of these cases. Let me move on to the next slide. There can be special problems that can arise with Section 8 voucher rents. You might have tenants who can't rent an apartment because their gross rent is going to be more than 40% of their income, or the owner wants to increase the rent and either the housing authority can't approve it or it's more than the tenant can afford. Or particularly in domestic violence situations, you may have the survivor is moving and they counted on having the subsidy given the family makeup. So let's assume you said, I'm going to move now because it's really much safer for me to port out of this community completely. And they thought, I'm going to qualify for a 3-bedroom subsidy, and that will work for me. But they moved to the new housing authority, and the new housing authority says, oh no, we have a rule here that says that unless children are of a certain age separation between them and they're of opposite genders, they share a bedroom. So in your case, you only qualify for a 2-bedroom voucher, and your client can't find a 2-bedroom, an apartment within that rent range for a 2-bedroom voucher size. So that's a problem that you could run into. Another common one is on the next slide, which is the spouse leaves, and because of that, suddenly the housing authority says, well, you did qualify for a 3-bedroom before now because you had separate bedrooms. There were health reasons that you were in separate bedrooms, but now you only qualify for a 2-bedroom subsidy, and therefore we're going to reduce how much we pay as rent for you, and you're going to have to either figure out how you swing the balance, or you're going to have to move to another unit. And then the 5th one is, and this unfortunately has become all too common, housing authorities running into a financial crisis and saying, oh, we can't cover all the assisted tenancies that we have here now, and we've got to cut people's subsidies, or we can't process people on our waiting lists, or maybe we have to terminate some people from our program. And the landlord says, well, you know, it's your problem. You're going to have to make up the difference, tenants. All of these 5 situations, particularly the 3rd and 4th one, are unique to domestic violence, but are very, very common problems that Section 8 voucher tenants can run into, and they're very unique to the voucher program. We really don't have enough time in this training to sort of go through all the different types of problem solving or thinking that people have done about that, but just be aware that there are some innovative solutions that people have as to sort of how to best advocate with your housing authority around maybe getting them to have it be a higher bedroom size, or considering some alternatives to what the housing authority may be considering otherwise, or thinking about, are there other housing authorities that might be able to administer the voucher in the same area. So I think I'm just going to have to stop at that point because I know we're running short on time, but just want to identify that those are other unique problems that you can run into with voucher rents.
And Malia, are there some questions that have come up that you have not given us that are?
Sure. So we can probably have time for a few questions. One I see in here is, if the survivor is trying to argue that the abuser has left the home and the rent should be decreased, is a simple written statement from the survivor alone enough proof of the separation?
Different people may have different thoughts on this, including Barbara and Linda. But I think that normally if you have something else and can provide something else in addition, it would always be better, because normally the owners and PHAs have gotten used to HUD telling them that they need to get third-party verifications. But if you can't, and you've sort of racked your brain and your client has racked her brain about thinking about what can be done, yes, I think a self-statement is sufficient.
Okay, thank you. And Kathy, if you could go ahead and move to our contact information on the slides just so people have it as we wrap up here. So another question that came in is, if the client is delayed in responding to a housing provider's request to certify her income, what are some acceptable reasons the client could give for the delay in completing the certification?
Well, I mean, obviously we've talked about the situation in the context of the client who was away from home because she had to flee with her children and then came back and was late on getting her annual recertification done. So that would be one example of that. Obviously there may be circumstances in which someone's hospitalized. There may be an interaction between issues of disability as well, and there may be reasonable accommodation arguments that exist in some cases about why things aren't provided, particularly if the client can help establish that maybe the delay was for circumstances beyond her ability to control, like she had contacted X place and it took them longer than she expected to get things back. Then that shifts things again to that earlier example that Catherine gave, where you don't penalize the client for the third party's failure to come through with documentation on time. I don't know, others can add to this as well.
I mean, I think some of it is also, in terms of how much time the provider has given the person to respond, and it also goes back to whether or not the provider, I mean, these are procedural questions. Did the provider give sufficient time? Did they follow their own rules in terms of how much time they would give to people to respond? I mean, there are some cases in which a housing authority, gave somebody kind of like over the weekend to come up with substantial documentation, and the court said, no, that's insufficient.
All right, so unfortunately I think we have to wrap up now, and I realize we didn't get to everyone's questions, so we will try to respond to those questions offline. It may take us a couple of weeks to get back to you, but we are cognizant of your important questions, and we'll put that on our to-do list to get back to you individually by email. Our contact information is on this last slide. Please, if Kathy, you could go back to the contact info. Please feel free to email us or call us if you have questions about anything we covered today. I recognize that a lot of the material is a little, might have seemed overwhelming because it is a lot of information and it can be complicated to know whether your client is paying the correct amount of rent or is entitled to reduction in rent. So we're happy to take follow-up questions from you all. Do any of the presenters have any closing thoughts before we go?
No, I just appreciate the opportunity to be on the webinar.
Yes, and I definitely want to, again, thank our presenters and our consultants from Greater Boston Legal Services for all of your helpful feedback and the amount of time that you put in preparing for this training. I think, it's a huge resource for advocates who are starting to work on these issues.
Yeah, and I want to emphasize again, thank you to Mac who presented, but also thank you to Barbara and Linda who really helped us try to frame this presentation in the context of issues that would arise in the context of domestic violence.
All right, with that, we'll close. We'll send you evaluations via email as well as a recording of today's training. We really appreciate your feedback, and thank you again for your time with us today.